Proceed.
So we are delighted to be part of this year's program, and we commend the coordinator and the Rule of Law Development Foundation from what they are doing. What they are doing is not only enriching Nigerian jurisprudence, it's also enriching African jurisprudence, because I think the thing is watched everywhere. We in commending him, we beg other people in Nigeria or Africa that have the opportunity to do this type of thing to assist, because we know that the problem of Africa has to do with bad governance. And what this conference is trying to do, especially in challenges of insecurity and economic hardship, has to do with also bad governance. Because if we have good governance, we will never have insecurity or this economic hardship. I've watched what the connector has said, and the week is full of enriched topics, and people will really give their buy-in and say what is good for the administration of justice, criminal justice in Nigeria. What we continue to do, is to pray for the coordinator and pray for this Rule of Law Foundation to still have the wherewithal all years to try to bring this to fruition. So, in that light, we say thank you and wish you fruitful deliberation. African Bar Association is with the Rule of Law Foundation all out. So, thank you very much.
Thank you very much. That is the president of the African Bar Association, Mr. Ibrahim Eddie Mark. We now move on to the Glass House in LOKOJA. We want to hear from one of our major collaborators in this year's conference, the Honorable Attorney General and Commissioner of Justice, KOGI State, Muizideen Yunus Abdullahi, Senior Advocate of Nigeria.
Thank you, my brother, Paul S.A.N. I don't know if you can hear me over there. Paul, can you hear me?
We can hear you. You can proceed.
Excellent. My special greetings to the coordinator, father in the profession, Chief J.B. DAUDU, S.A.N., and the keynote speaker, Mr. Olanipekun Olukayode, the Executive Chairman of the Economic and Financial Crime Commission. I seek the indulgence to stand by the existing protocol, but with particular recognition of the delegates from KOGI State, particularly my lords of the High Court, who are here with me, and the chief magistrates, together with the permanent secretary and the directors of the Ministry of Justice. I am honored to extend warm greetings and goodwill to this prestigious Criminal Law Review Conference, organized by the Rule of Law Development Foundation, ably led by a bar leader par excellence, Chief J.B. DAUDU, S.A.N., who has done this successfully since the first edition, if I could remember, 6 years ago. The contribution of the organizers to the development of law over the years must not go without recognition. Their consistency and drive for achieving the objectives of the foundation is worthy of emulation. No wonder Brain Tracy said, and I quote, "Consistency is key to achieving success." By the way, the Rule of Law Development Foundation was set up to promote the development of the rule of law in Nigeria, Africa, and the world at large, promote and encourage legislative advocacy skills within the ambit of the rule of law, and to promote justice system reforms. It is in recognition of the lofty objectives of the organizers and their tireless effort towards achieving those set objectives vis-a-vis the commitment of the government of KOGI State under the able leadership of His Excellency Alhaji Ahmad Usman Ododo to promoting and observing the rule of law that for the 6th Annual Law Review Conference 2024, the government of KOGI State decided to sponsor an array of participants drawn from the state judiciary, official bar, as well as the private bar. Not only has the government offset conference registration fees, it also made available its premises, that is, the banquet hall, Government House LOKOJA, for virtual participation for those who cannot proceed to Abuja, the physical venue of the event. This is His Excellency's way of identifying with what is good and consider in tune with the ideals of the government. As we gather today to explore the intricacies of the law and its impact on our society, I am reminded of the profound role that legal scholarship plays in shaping our understanding of justice and promoting the rule of law. The conference is particularly important as it creates an avenue to review the journey so far in our criminal justice system and to make meaningful suggestions towards advancement in the criminal justice sector. There is no gainsaying that the need for performance evaluation for the purpose of improvement is key to any system that is or will be properly functional and a system that seeks to be in tune with global standards. This conference represents a unique opportunity for experts and thought leaders to converge, share knowledge, and chart a course for the advancement of criminal justice system in Nigeria, Africa, and the world. I therefore commend the organizers for their tireless effort in bringing together such an impressive array of speakers, panelists, and participants. As we engage in robust discussion, debates, and analysis, let us remain committed to the pursuit of excellence, intellectual curiosity, and the dissemination of knowledge. May our collective expertise and passion for the development of law illuminate the complexities of our rapidly changing world and inspire innovative solutions. I wish you all a productive, enlightening, and enjoyable conference. May your interaction foster meaningful connections, spark new ideas, and contribute significantly to the ongoing conversation on the evolution and growth of the criminal justice sector. I appreciate the coordinator for this privilege. Thank you so much.
Thank you very much, our Honorable Attorney General and Commissioner of Justice, KOGI State, Mr. M.Y. Abdullahi, Senior Advocate of Nigeria. Thank you very much. We see all His Excellency is doing for the enthronement of good governance, and we send our warm regards to all my lords there present.
Recording in progress.
Both in the private and public bar there. Thank you for being with us. You agree with me that we are in for a robust and interesting conversation. Starting from 12:30, we're a bit behind schedule, but we'll be starting the next session at 12:30. Now is a good time for us to break for our tea break, which will be served at the foyer here. And I'm sure there are preparations in LOKOJA for the tea break. Okay, we have here, it's showing on the screen now where we'll be taking our tea break. So our delegates who are physically present will proceed to our marquee outside for the tea break. It's an opportunity for all of us to network and get to know ourselves. Usually at this stage, we also do group photographs with some of our invited guests. The red carpet is actually outside for group photographs. So I'm sure immediately after we take the national anthem, we'll disperse for our tea break, and we'll come back at 12:30 for the topic, criminal conduct arising from the prevailing insecurity in the nature of terrorism, kidnapping, banditry, breach of peace, unlawful assembly, riots, violent protests, and other related offenses. You agree with me that these are front burner issues which not only lawyers have been privy to, but they have been national issues that have come up in the news recently: the End Bad Governance protest and the never-ending fight against terrorism and kidnapping. We are going to be listening to our own lead presenter, JB DAUDU SAN, our coordinator, who will be doing justice to the criminal aspect of all these societal evils. And we also have Ahmed Raji, Senior Advocate of Nigeria, joining us, Paul Erokuro, SAN, joining us. We also want to hear from Nigerian Police Force. Particularly these recent times, they've been receiving some backlash from the public due to what happened at the Federal High Court some 2 weeks ago. It will be good to hear from them. And even the Nigerian Correctional Service, we are also aware of what happened recently. Some allegations came up with regards to some suspects and convicts that were in their custody. We also have INEC also joining us. So you agree with me that we're going to have a very, very robust and engaging session. So we will just take the national anthem now and quickly adjourn. We'll do a group photograph after the national anthem and proceed for our tea break. So let us have our national anthem, please.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. To hang unto our children a banner without stain. O God of all creation, grant this our wandering first. Help us to build our nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed.
Thank you very much. So we'll take the group photographs with some of our distinguished guests on the top table with the coordinator here, and then we proceed for our team.
Let's see, sir. Yes, no, we will take it. We are using the banner there, the banner at the background there. So we'll use the banner as the background for the photograph. No, it's not question. Yes, sir. Thank you.
Hello. We know. Thank you, Abdul. It's only for the resource persons. The others can. There's a networking zone outside. We invite you outside as well. But for the resource persons, can come and take the photograph here. So the photographer, please organize it. There's also a red carpet outside for our delegates who also want to take their own pictures. We encourage you to do so.
Project manager in this organization. I'm so happy that you people have sit and looked at you may come this community and take some of my children to teach them how to good in future. I'm saying thanks to you.
I'm the most happiest person this morning because of what the rule of law has brought to my community.
It's a good project that will boost the children, their career, that at least they would meet up with the target of their living life. And for that, I pray for this, the organization, the rule of law for development, for
started with 5 communities. Waru community, I mean this is Waru right now. There is a Kabusa community, there is Karumajigi community, there's Kuchingoro community, and finally there is Kurudu community. And we have 20 boys in each of these communities. So we started, of course, by
all together. Oh, bring us together. One love, one love, one love, oh, one love, one love, one love, one love, oh, one love. Bring us all together. Oh, one love, bring us all together. Bring us all together. Oh, one love, bring us all together. Shi da shiku da shikuna haushi, mu da su da ku ana fushi, mu koma baya manta da mai laifi, kashen juna baye da masala. Wanna see Hutus and Zulus, Fulani, Conakry, Yoruba, Jula, Eritrean, Libyan, dukanmu mu shirya, ni da kai ke da ni mu taimaka. Ha! One love, one love, one love, oh, one love, one love, one love, one love, oh, one love. Bring us all together. Oh, one love, bring us all together. One love, one love, one love, oh, one love, one love, one love, one love, oh, one love. Bring us all together. Oh, one love, bring us all together. Africa unite, say Kwame Nkrumah. Give me the voice of the great Nelson Mandela. Energy of hope like Thomas Sankara. Resilient, defiant like Baba Fela. Musa Chore, Chinachebe Suketure. Patrick Lumumba, Gaddafi, Haile Selassie. African unity is all that I see. If you know that we are one family and you throw them stones just to hurt me, don't forget one day when you need me. Turn around, what you see, be burn bridges. So one love, keep us all together. One love, one love, one love, oh, one love. One love, one love, one love, oh, one love. Bring us all together. Oh, one love, bring us all together. One love.
The community leaders, and we brought a letter introducing the project and what we wanted to do. And during the advocacy, I remember meeting a father at Kachingoro community who told
sessions. And this session, as I stated before the break, concerns criminal conduct arising from prevailing insecurity in the nature of terrorism, assembly riots, violence, banditry, breach of peace, and other related offenses. And to do us justice in this session, I will soon hand over to the panel. We have with us here the chairman of that session. Can you give a round of applause to Honorable Justice M.A.R. Oredola, JSC retired? For those of us who have not met Justice Oredola before, no, JCA. Sorry, my lord. My lord is a retired justice of the Court of Appeal with extensive years of legal experience. He served at the Court of Appeal before his retirement. His tenure involved numerous significant judgments and rulings that have contributed to Nigerian jurisprudence. He is known for his wisdom and respect for rule of law. Following his retirement, he has been involved in various legal and judicial activities, including serving as a chairman on several panels and committees. He has presided over high-profile cases, I have said, and is always here for us as a friend of the rule of law. Our lead presenter is our coordinator, JB DAUDU SAN. Please let's give him a round of applause. Who is the principal partner of JB DAUDU & Co. Is the coordinator of the Rule of Law Development Foundation, and his CV, if I read out his CV, won't be able to live here today. But I would just say he's a prominent Nigerian lawyer, obviously an SAN, a distinguished career in legal practice, including his specialism in criminal litigation, constitutional law, arbitration. The list is endless. Let's give him another round of applause. So we'll be hearing from him on his own perspective of the topic. I understand he will be joined by erudite learned senior advocates of Nigeria to discuss the topic. And we have Ahmed Raji, senior advocate of Nigeria, who is also present, but ably represented by Mr. Wale Balogun, senior advocate of Nigeria. Please let's give him a round of applause. I also understand that we have the representative of the Independent National Electoral Commission, INEC, online. Please, we are also expecting feedback from the police and the correctional services in the event that they are here. So at this stage, I will be assisting the chairman whenever he needs any information, or permit me at this stage to hand over proceedings to the chairman. Please, let's give them a round of applause as we begin discussion.
Good afternoon, distinguished participants at this 6th annual Criminal Law Review Conference of the Rule of Law Development Foundation. I must say that I feel honored to be asked to come and be the chairperson or chairman for this session. And I want to say from the outset that I won't take much of your time in saying a lot, because you are going to hear a lot. Before I go further, let me seek your indulgence to retain and remain on the established protocol, which has been ably done by the MC and earlier on. Now, the topic has been read out, and it is to be fully understood that the coverage of the paper, I won't let the cat out of the bag. I have not even seen the bag. Talk late of letting the cat out of the bag. But that the coverage and the essence of the topic is an assessment, an evaluation of the emerging systemic challenges of insecurity and economic hardship excuse me, in the past 12 months. We are all witnesses to the fact that this country for quite a long while has been bedeviled by an alarming rate of insecurity. So the question is it that the problem is unsolvable, intractable, or it is just that we are not doing enough? But like I said, the lead paper, which is to be presented by the founder and coordinator of the Rule of Law Development Foundation, is going to be, I'm assuring you, is going to be deeply well researched, going to be a deep-rooted food for thought, and it's going to be a learning experience and curve that I believe everybody will take away practical learning at the end of the day. So I will reserve my comments till after the delivery and towards the rounding up. Please bear with me. My voice is hoary. I've just been coming out of malaria catarrh episode, but I owe it a duty to be here. So without much ado and wasting much of your time, since we have, like I said, we are going to enjoy and we are going to learn and gain. So I will ask you to please usher in or welcome the presenter of the lead paper, and then let us attentively and retentively listen and learn and imbibe. Chief DAUDU, the floor is yours. Okay.
Our eminent chairman and all other protocols duly observed. I welcome you all to the first working session of this year's 6th Annual Rule of Law Development Foundation Criminal Justice Conference. As usual, this paper will examine the developments in the last 1 year in the area of substantive criminal law, as it pertains to the court system, the legislature, and the reaction of stakeholders such as the investigative and prosecutorial agencies. So that is talking about the EFCC, ICPC, Nigerian Security Civil Defense Corps, the Department of State Security, and many others. Where relevant, procedural developments as they relate to these identified areas will be considered. When the present administration took over the reins of power on the 29th of May 2023, they inherited the problems of insecurity, weak economy, and rising criminality in the society from the administration of President Muhammadu Buhari 2015 to 2023. Crimes of kidnapping, terrorism, abductions, human trafficking, armed robbery, electoral offenses were prominent and indeed rampant within the territory of Nigeria. Indeed, terrorism and kidnapping for ransom were so widespread that it disrupted the economic lives of millions of Nigerians who relied on farming and allied preoccupations for a living. Put in simpler terms, the level of insecurity became so heightened, having regard to the number of people who had lost their lives and displaced from their ancestral villages by these armed marauders, also known as bandits and or known as herdsmen, that it impacted on the ability of Nigerians, especially those in the 19 northern states, to eke out a living from land. Consequently, government had to resort to importation of basic foodstuffs such as wheat, maize, rice, poultry products, etc., to meet up the shortfall caused by these acts of incessant banditry and the concomitant disruption of lives of the people. The decline in productivity in the agricultural sector, coupled with the removal of fuel subsidy and the rebasing of the national security, that is the legal tender, the Naira had the unwholesome effect of pauperizing the populace and destabilizing the socio-economic and political equilibrium of the nation. To correct or reverse this dangerous and indeed calamitous trend, which has the potential to destroy the entity called Nigeria in every imaginable ramification, the present leaders must address the issue squarely and desist or cease from mouthing mere platitudes of hope and other insubstantial and indeterminate solutions. Instead, our leaders should, as a matter of urgency, come up with a roadmap of a clear path to economic and social recovery. This plan must be real, concrete, and must have a commencement point and a termination date. It must be a plan that is amenable to be tested against realistic parameters. In other words, it must go beyond saying, "I feel your pain," or "there is light at the end of the tunnel." The roadmap must identify the route that will take us to the tunnel and out of it. We are tired of being told that things will be better in the end. This refrain has been drummed into our ears since the era of the Structural Adjustment Program, SAP, of 1987. And from then onwards, things had become progressively decimated. We are now at the point of decisive action, and no sector of the society can afford to fold its hands akimbo and watch the Nigerian society slide into anarchy. The present decline can be arrested in the following manner. A. Fight the scourge of insecurity frontal and make it a matter of national emergency and priority for the dislodgement of all persons terrorizing the citizenry through the avenue of banditry, illegal mining, terrorism, armed robbery, trafficking in human parts and persons, kidnapping, abductions, and other allied offenses. B. Provide stability for the Naira by halting its current free fall and pegging it to a determinate rate vis-a-vis other global currencies. This will arrest the current free fall of the Naira and its attendant consequences of inflation and other effects, such as the devaluation of Naira. Fight corruption with all the arsenal at its disposal, as the non-factoring of the fight against corruption in all the developmental proposals has made or brought about the collapse of all initiatives to revive the economic fortunes of this once potentially great nation. Now, let me just expatiate on this. That any plan you bring in Nigeria, any formula you bring, will not work unless you factor in the removal of corruption. No matter how beautiful your plan is, it can be destroyed by the scourge of corruption. Just need one person to frustrate that plan because he has a corrupt motive or interest. And a plan that is worth billions of naira will collapse on account of somebody planning to eat 30,000 naira. And so we must make, like the EFCC chairman said, acts of corruption to be unproductive or to be not to be palatable again for people to want to engage in it. The next one is D. Boost agricultural productivity to stave off famine, hunger, and other indescribable consequences of the inability to farm and grow agricultural products. And E. Provide some form of energy subsidy to keep prices of all commodities down. Again, it is clear that we cannot allow the cost of power and electricity, fuel, and other energy base to keep rising without determining it or pegging it to a price. No country has ever survived without energy subsidy. Even the United States of America and other democracies that we copy cannot survive without keeping the price of their energy at a reasonable subsidy, at a reasonable level. So for us to keep it open to market value, our market vagaries of market force is a product of corruption too, because people are only looking at the margin of profit that they are going to make from manipulating prices at the expense of the comfort of the people. So if these 5 proposals are implemented, I'm sure that the present problem will ease. I'm sure you'll be surprised that I proffered solutions at the beginning of the paper. It merely shows that it is a sign of what probably is to come, or maybe what is to come will be an anticlimax. The role of the criminal justice system in ending the prevalent insecurity in Nigeria. The Nigerian criminal justice system consists of several elements or components, starting with the law enforcement and criminal investigation units, such as the Nigerian Police, EFCC, ICPC, NSCDC, and a host of others. Now, I mentioned the others in the paper. The essence of these security organizations is to enable Nigerians sleep with both eyes always closed and carry on their business without let or hindrance. However, rising insecurity and criminality has exposed the Achilles heel of our security agencies. All over the world, law enforcement agencies prevent and or resolve 50% of all criminal activities at the stage of planning or at the
recording in progress
or at the point of execution, thus sparing their home societies the agony of pervasive insecurity. Our experience shows that our law enforcement agencies will for a long time to come lack the capabilities to contain the rot and criminality within the system if certain remedial measures are not taken. What are these measures? To appreciate which measures to apply, it is necessary to ascertain the problems presently militating against crime prevention and enforcement in Nigeria. Taking the Nigeria police force as an example and starting from the base, there is the existential problem of rampant corruption within the system. Whether we like it or not, the average Nigerian sees his relationship or contact with the average policeman on beat as transactional. Although one of the most sung refrain of the police is that bail is free, but the reality is that it is not. The pessimism is such that victims of crime prefer not to report the matter to the police or their encounter with crime to the police because of the likelihood of incurring additional and indeed more needless financial expenditure. There have been rampant incidents of complaints of victims being required to fuel squad cars before police officers can visit the scene of crime, or paying for the stationery on which their statements and complaints will be recorded. It will not be necessary to give further examples so as not to lose sight of the objective of this discourse, which is primarily to find the solution to these existential problems. The wrath or menace of corruption is not limited to the police or other law enforcement agencies. It is a nationwide scourge found in almost every public institution and even in private society. It is so rampant that it has become a cancer, and like all cancers, it eventually kills its victims if not treated or dealt with at its early stages. How do we kill corruption before it kills us all? The answer is to eliminate in the harshest manner possible every trace of corruption in our system. Of course, it may look difficult or impossible to curtail or eliminate, as beneficiaries of the wrath are always reluctant to forego such ill-gotten wealth. The courts and the adjudicatory system. Our courts represent the bastion of the judiciary and is the entity from which justice is served to the people. Recently, familiarity has bred contempt between the courts and the people, such that it is now a rampant war cry from certain sections of the social media that the judiciary is corrupt. That should not be any news, as Nigeria has been described as, in certain quarters by influential voices, that it is a fantastically corrupt nation. The former British Prime Minister was the one that used that word. And it is expected that a few bad eggs will exist in the system. But I take exception to tarring every judicial officer with the same brush of corruption. And I say it is akin to throwing away the baby with the bathwater. In other words, this is a Nigerian institution, and therefore, because of the rampancy of corruption in the system, we cannot say that a few will not have slipped into the system that gives the system a bad name. But it is not all judges that can be said are corrupt. I do not intend to lose sight of the topic at hand. It is about the way and manner our system should respond to emerging criminality or acts of crime, as have been described and enumerated above. What is required to tackle and withstand this tsunami of insecurity that is about to overwhelm Nigeria is a judiciary that is optimally fine-tuned to deter criminal trials expeditiously, and the proper and due performance of this function is the only panacea to the said insecurity. By way of digression, we must recall and place on record that Nigeria is a federation comprising of the Federal Capital Territory, Abuja, and 36 states. This means that the nation has 37 supposedly functional judiciaries, which ought to be capable of bringing persons accused of criminal acts within their respective territorial jurisdiction to account for the crimes alleged against them. Why does it therefore appear as if it is not possible to prosecute and convict certain crimes within the territories of states where the alleged criminality of criminal acts is said to have been committed? I ask again, why is Abuja the Federal Capital Territory the choice of prosecution for simple crimes allegedly committed within the territories of states? What is the motivation behind bringing simple complaints, commonplace offenses like arson, disturbance of public peace, conduct likely to cause a breach of the peace, affray, criminal trespass, destruction of public property, theft? Why is it that these simple cases are brought to the Federal Capital Territory for prosecution? The answer can be discerned from the incidents or recent episode that I'm about to allude to in answer to the poster above. On the 9th of August 2024, in a speech at the sent forth ceremony for extant students from the Nigerian Law School who had just completed their 6-week law school law attachment, law chamber law office attachment in our Abuja office. I commented on the recent End Bad Governance, hashtag End Bad Governance protests that went on for 4 days, 10 days, and engulfed parts of the nation from the 1st of August 2024. For those who probably didn't see what I wrote or weren't privy to the speech, I would just like to read it. It's not too long. These motley groups found a unified cause in the hashtag End Bad Governance protest, which commenced. Although it appears to have lost steam, I do not intend in this discourse to delve deeply into the remote and immediate causes of the present economic and political crisis, except insofar as it will be relevant to drive the point being made here home, which is what should be the role of a trained lawyer in times like this. But before going into that, it is necessary to examine the dynamics of a protest, which most legal practitioners seem to assume is a constitutional right and indeed a fundamental right at their beck and call. Nothing can be further from the truth than this ignoble proposition. Firstly, Section 40 of the Constitution of the Federal Republic of Nigeria guarantees the right only to peaceful assembly and association, which by extension guarantees the right to express one's dissent to acts of governance that are inimical to one's progress, especially where it is perceived to be debilitating, detrimental, or inimical to the well-being and interests of the citizenry. For this right to be a protest, in quote, exercisable within the ambit of Section 40 of the Constitution, it has to be peaceful and devoid of any riotous activities. This is based on the constitutional stipulation that one man's right ends where the rights of another man begins. Thus, a protest ceases to be a protest when protesters take a violent stance, when its participants light up bonfires on streets and roads, burn tires and other incendiary devices, force non-participants, innocent bystanders, harmless road users, and indeed the general public to identify with what is now clearly a riot by holding leaves, branches of trees, and other objects to force them to identify with their riotous procession and its underlying political motivations. Understandably, this kind of riotous situation is usually a prelude to anarchy, and at that point, any responsible government must step into the void and provide security for the enforcement of peace, law, and good order in the society. By way of postmortem, the majority of analysts claim that the protests were hijacked by undesirable elements, looters, and other cadre of criminals, including insurrectionists and terrorists. This is unfortunate, as what is expected of government is to roll out the full machinery of the law as laid down in our repertoire of legislation, such as the Penal Code, Criminal Code, Violence Against Persons Prohibition Act, Anti-Terrorism legislations, and the Public Order Act, and other legislations, and, underlined, prosecute all those who violated the law and caused mayhem in the name of peaceful protest to a logical conclusion. Now, when we called for the prosecution, at this end of quote, when we called for the prosecution of persons suspected to have masterminded or participated in the aforedescribed riots, we did not give that advice to government and other persons in authority to misinterpret the situation or take advantage of the prevailing circumstances by dragging off minors, hundreds of minors from all corners of the Federation to be charged in the Federal High Court, Abuja, for the high crimes of treason, sedition, etc., which are either capital offenses or quasi-capital offenses. What happened afterwards in the Federal High Court before the Honorable Legua Tuje which saw many children in poor, malnourished conditions suffering fainting spells in open court while they were being arraigned of the charge of treason, may appear to be history, but it is personally etched in our national psyche. The reactions by Nigerians on the pitiful scenes that emerged from the Federal High Court Abuja were greeted with adverse, spontaneous reactions. On my part, I reacted thus on my Facebook post platform by post thus, and most of you have read it, but I would read it again so as to make a link with where we'll eventually land. The only thing obscene about the Federal High Court proceedings in Abuja yesterday is the nature of the charge, which is allegedly treason. Minors, and that is if they are less than 16 years old, are usually treated as adults when they are found committing crimes. So had they been charged for the right offenses in the territory of the states where they allegedly have misconducted themselves, I would have had no problem. For me, the highest offenses that they could have, and that means these young children, could have been charged for are conduct likely to cause a breach of the peace, unlawful assembly, willful destruction of public property, theft, otherwise known in the south of Nigeria as stealing, and other offenses of like nature, affray, which are not only state offenses. They are not just state offenses, but are bailable offenses. Thus, the Attorney General of the Federation had no locus to charge any of the young men, but I have been corrected that the Attorney General knew nothing about it, and even when he knew, he had to now tell the IG and the relevant DIG not to arraign them for treason before the Federal Capital Territory. But I hear, if the police were here, they would be able to defend themselves, that all their pleas fell on deaf ears. So, while I still say that the Attorney General himself would have had no locus to charge the young men for any offense committed during the #EndBadGovernance riots, except within the territory of their respective states. It is a complete caricature of federalism that we claim to operate in Nigeria, where state governments abdicate their responsibilities to the federal government. And Kano State government was guilty of this. Kano State allowed hundreds of her children to be dragged to Abuja, charged to court, only for the governor, when it was time to play politics, to fly in private jets to come and collect the children, and then say that he's sending them to school, they're taking medical treatment. Such crass politics should not be played in the north of Nigeria. We should go beyond that. So they turned a blind eye. No governor should have allowed their citizens to be taken out of their state to Abuja. The simple thing they could have done was within 24 hours after their arrest to have charged them before the local magistrate court or juvenile court or the Sharia court or whichever court has criminal jurisdiction. But to allow police carry your children and take them to Abuja under the guise that they are being charged for waving flags, which is, I think, an offense under Section 115 of the Penal Code, which could have been charged in the magistrate court in Dala or any other place where the magistrate courts are in Kano. So I continued by saying that for the avoidance of doubt, there was nothing treasonable in the conduct of these children or young men as discernible from the charge. And if our systems were working, they could easily have been charged for the offenses mentioned above in juvenile or magistrate courts within the territories of the states where it is alleged they committed the offense. One point is clear here, which appears to have been glossed over by a lot of, is that the defendants, be they children or adults, have already spent over 3 months in very dehumanizing detention conditions. This is very inhumane and a breach of their fundamental rights. It is my view that even if they committed the offenses that they are being accused of, certainly not treason, the maximum sentences that could have been handed down should have been reasonable fines and in serious cases imprisonment, not exceeding 3 months in the proximate correctional facility or Bostal institution. Around about the time that we were having this hashtag End Bad Governance riots, England was having its own hate crimes riot. And all those who participated, who were lighting bonfires, were charged to court within 24 hours. According to the gravity of the offense, none was sentenced in excess of, the ones I had, 2 weeks, 3 weeks, some fines, cautioned and discharged, but they were made to go through the judicial process so as to act as a deterrent. But here, we played politics with them. Maybe people were looking for, to use it to get money from the federal government for as a special project, bring hundreds of youths into Abuja to languish in detention for 3 months. So, I call on the FGN to discontinue these charges and release all those charged for these state offenses with adequate rehabilitative compensation paid to them. One last point is to interrogate, well, this last part is to say whether anybody died in custody, because this is Nigeria, nobody will tell you, and that there should be an inquiry, and that a nation like Nigeria, who is aspiring to be in the Security Council of the United Nations, should rise above certain standards of that are below international based standards. So that was what, but to the credit of the Tinubu administration, it recalibrated after hearing views like this. We've actually adopted all the proposals here, and the president showed some remorse and released the children to their respective state governors. I think only 2 states were involved, Kaduna and Kano State, but Kano was the bigger culprit. And extended the milk of mercy and presidential forgiveness to the hundreds of these young persons, by ending the charges of treason against them and repatriating them to their home states for rehabilitation and re-education. Does the matter end there? It should not, because there are serious lessons to be learnt therefrom. What are these lessons? The first and most prominent arises from the implications of the federal structure system that we practice in Nigeria. As stated earlier in this discourse, this country is a federation comprising of the center and 36 states. It is an anomaly to move out domestic criminal allegations within the competence of the states where they occurred to Abuja, the Federal Capital Territory, in order to foist on taxpayers the expenditure associated with charging these helpless citizens with the high crime of treason. As identified above, these are minor crimes arising from emotions and flared tempers and the consequences thereof. And if emotions and flared tempers arose legitimately because they were feeling hardship, there was hunger in the land, prices were going up, and people's lifestyles crashed. So it was justified for certain pent-up tensions to be released. It is my humble but considered view that it was absolutely wrong for the state authorities, that is, the attorneys general of those states, whose citizens were involved in the said, in quote, treason, to have allowed their citizens to be ferried off to Abuja and tried for simple state offenses. These chief law officers ought to have been proactive and at the earliest opportunity should have arraigned the suspects before their appropriate juvenile or magistrate courts within their jurisdiction. Had they done so, the Nigerian police would not have gone ahead to spirit off hundreds of teenagers in poor sanitary conditions to Abuja to satisfy their broader their superiors. In the practice of crime prevention and prosecution, the time has come that we should revert to the federalist structure of the system we profess to practice by ensuring that the state governments assert the full local jurisdiction to prosecute and administer justice on persons who flout the law of crimes within their respective jurisdictions. This will free the federal authorities like the police, the EFCC, and like agencies, to concentrate on strictly, purely offenses against the federal structure of Nigeria. It is humbly submitted that states, in the pursuit of their crime fighting jurisdiction, should operate a pyramid model. In other words, solve crime issues from the base upwards and not from the peak downwards. The best model is to have a ward or a group of wards within a local government of the state, and they should have their own law enforcement machinery, such that if it's a big ward, it should have its own police station. If it's a group of wards, it should have its magistrate, customary, or special court system, so as to deal with domestic crimes that arise within that jurisdiction. It is also apt to suggest that every local government in the federation should have its own prison, custodial center, or awaiting trial center, so as to discourage the movement and transfer of suspects from one end of the state to the other at times. And I've known there was a time, while I was still very active in Kaduna, they had to move suspects from Guantu around in Sanga local government area, a distance of over 300 kilometers, to Ibrahim Taiwo police station in Kaduna over a minor offense of just people fighting. So I don't know, the police usually have their own formula, but I don't know why anybody should be moved a distance of 300 kilometers. At best, you should have kept them in Kafanchan, but they had to be brought to Ibrahim Taiwo Road. It is this model, wrong as it has been, that was replicated, that now being replicated between the states and Abuja, thereby resulting in the unfortunate scenario of moving local state minors and matters from their state jurisdiction to Abuja. The second area of interest in the 1st November 2024 arraignment of these young persons, as referred to above, arises from the bail conditions granted by His Lordship Honorable Egwatu J. after the charge of treason was read to them, to which they pleaded not guilty. It was reported that they were each granted bail by His Lordship in the sum of 10 million naira and 2 shorties in the like sum, with one of them who must be a director in the Federal Civil Service. As a result of these stiff bail terms, a lot of people criticized His Lordship on the ground that the bail conditions were too harsh and not a proper exercise of his discretion. However, you'll be surprised to note that in my humble view, I think that His Lordship was needlessly subjected to unfair criticism. This is because His Lordship, by the existing rules, on the grant or refusal of bail application, was obliged to consider the severity of the charge, which in this case was at its highest level, treason. Now, if you bring a murder charge before a judge, he is obliged to grant bail in consideration of the severity of the charge of murder. He will not say, because, oh, these are minors, that I will impose bail conditions that will just be like telling them to take a walk away from the judicial process. So therefore, I felt that since His Lordship was obliged to consider the factor of severity of the charge, which, as I said, was at its highest level, treason, His Lordship must also have had in mind the constitutional principle that the accused persons were presumed innocent until proven guilty. So he was also equally obliged to balance the fact that they had yet, their guilt was not yet proven, and that they were presumed innocent until proven guilty before granting the terms of bail. So if you look at the terms of the offense of treason and the bail conditions, my humble view is that he was just a victim of circumstances. And he could not jump into the arena to say, I've read the proof of evidence, I therefore don't think that the offense is that of treason. Of course, he will also be castigated and criticized that he jumped into the arena and that he had taken a position. Why didn't he as well as discharge them? So within the limited purview of the fact that he was dealing with a treason offense, I don't think that the blame given on him, I think it was transferred aggression from the activities of the police was now transferred to the judge. I think he was a victim too of the misbehavior of the police. The take-home point here is to interrogate, why are we always too quick to blame the judex, leaving aside, as in this instance, the institution that should have taken the blame? Well, I'll say no more on this because an inquiry has been set up. I know we will not hear anything about the inquiry again, but since there is an inquiry that has been set up, I think we leave the matters as it is. And just leave the matter, but then my views have been expressed here. Now, the other second part of this paper is I've analyzed some cases, recent cases on kidnapping, terrorism, and etc. And a few cases. 2024 case of LOKOJA against the state, cited as 2024 Law Pavilion Electronic Law Report 61783. Just to underscore the point that the courts are still convicting, the courts are still convicting of offenses. And when you get the paper, you would see that I have reviewed 5 cases. Aclrc against the state, which is also a case on kidnapping, murder, and robbery. There is also Ekwenua against the state, and also 2024 case. We have reviewed it. And then we've dealt with terrorism cases. Berende against FRN 2023 for Nigeria Weekly Report, part 1875. And the old case, in relative terms, the 2021 case of Oguche against FRN, which is also a terrorism matter brought under the Terrorism Prevention Amendment Act. I have been directed by the chairman to abridge. So if you look at the paper, I have pointed to the amendments under the Terrorism and Prevention and Prohibition Act and set out the sections that were considered in the amendments. So this is in a nutshell the few things that happened in the area of insecurity, terrorism, kidnapping, and other crimes of modern fancy within the last 12 months. So I thank you for your audience.
Distinguished participants, please a more resonating and resounding round of applause for the founder and coordinator of the Rule of Law Development Foundation. You'll agree with me that we've been served a lot of food for thought, and since the session is going to be interactive with question and answer, I'm pleading that you should ensure that we make it lively and vibrant. But like I said, we will take all the presentation, then we'll now go to the interactive session. So the next paper to be presented is the one by Ahmed Raji, Senior Advocate of Nigeria, Principal Partner of Ahmed Raji and Co. He is ably represented by Mr. Wale Balogun, Senior Advocate of Nigeria too. But before he does the presentation, let me quickly give you a brief rundown on the biodata of Ahmed Raji for those of you who don't know him. Ahmed Raji, Senior Advocate of Nigeria, is a leading senior advocate of Nigeria with over 30 years of experience and expertise in criminal litigation, constitutional arbitration and mediation, election matters, and other broad areas of practice. The learned silk has conducted a lot of he's been appointed Resident Electoral Commissioner. He served in more than 5 states. And as a result of his astute legal approach to clients' cases, keen attention to details, the learned silk has personally been involved in more than 100 cases at the trial and appellate courts, including being part of the team that successfully defended NNPC in an international arbitration against Petrick Incorporation, a United States company. He has a very, very long list of academic qualification and certification. And without much ado, I'll ask you to welcome Mr. Wale Babalakin, Mr. Wale Balogun, sorry. It is the B at the beginning that tends to make you feel like Babalakin. Wale Balogun, Senior Advocate of Nigeria, who is representing Ahmed Raji, Senior Advocate of Nigeria, and whom I'm sure will do justice to the topic. Yeah.
Thank you, sir. Because I'm always very shy of facing the crowd. So, but with the permission of the chairman, I will do that. Mr. Chairman and distinguished coordinator, I'm very honored and privileged to in the feed, Mr. Ahmed Raji, SAN, who is would have loved to be here, but for some reason he couldn't make it, and I'm just here to discuss the very comprehensive paper, of course, expectedly, very well researched in this area. And of course, there's no a better person to give such a lecture than the coordinator, because of his very vast experience in criminal prosecution. If you look at some of the major criminal matters in this country, I'm sure he has featured prominently in them. And also can say that if there's anybody to also discuss some of all these fundamental issues with respect to these hot topics, terrorism, kidnapping, of course it's possibly Mr. Ahmed Raji too. If you look at some of the major terrorism cases in this country, he has participated in them too. So he has very wide experience. So we just listened to the paper together, and we can see that the issue of to discuss the paper is going to be a very major issue. But we consider the theme of the conference, and we've put down a couple of things. We have looked at the issue of the critical issue there is on this issue of some of the crises, criminal issues arising from the insecurity in our nation. Someone will want to also look at it. What's responsible for this insecurity in the first instance? The critical thing responsible for some of these insecurity issues are commission of crimes in the first instance. When you're talking about banditry, you're talking of some group of elements, some elements outlaws trying to take laws into their hands. That's criminality on its own, isn't it? When you're talking about issue of terrorism, it's a major issue here too. This is also another commission of crime. So when you put all these special of crimes together, you are talking of what has brought us to where we are. We can just conversely examine what has brought about this insecurity. One major element of it is what the paper presenter mentioned, the issue of bad governance. Of course, can you separate bad governance from the economic hardship that Nigerians are going through currently? The marriage of bad governance, of course, the offshoot of bad governance is economic hardship. We are looking at, of course, this somehow has been on for a while, not just because it didn't start during this Tinubu regime. Unfortunately, the country we have been experiencing bad governance in a while. And some of the major stakeholders in this governance, they have actually foretold this, that the hardship this country will witness. I'm sure some of us will remember Okonjo-Iweala and the rest of them, who have said, if we continue on this path, that the hardship this country will experience, it will be undescribable. Now it seems that prophecy, we can conveniently relate with it. But we must also take notice, within the global context, if you look at, what do you call it, Global Terrorism Index, and some other avenue to consider the criminality that is going on in the world, somehow, unfortunately, it has been on the rise globally. If we take terrorism as an example now, Nigeria, unfortunately, I think we are like number 7, number 8 of a nation that has been globally impacted with terrorism. And sadly, terrorism has moved from the hotspots, which majorly used to be the Middle East. It has moved to sub-Saharan Africa. And of course, we have had, and we are still having our own very big share of terrorism. Of course, what has actually taken the spotlight from terrorism lately has been this issue of, where, quote and unquote, the issue of unlawful assembly. Where it's not unlawful assembly, it's being referred to as treason. The lead speaker has spoken eloquently about the issue of this most recent one, which we are going to talk about. Majorly is to look at what are the laws that are actually involved in this. We look at the issue of the penal code. We have also looked at the issue of criminal code. And of course, we are talking about Terrorism Prevention Act. And we have also looked at Terrorism Prevention Amendment Act, which are the major legislation that we are looking at in all these issues of all topics in the last 12 months. Terrorism, kidnapping, banditry, unlawful assembly, rioting. These are the key issues, which of course we can say they have become worse as a result of the hardship that Nigerians are going through. So look at so many of them. You have also seen the role of the judiciary too. Of course, judiciary is also not in isolation, isn't it? The judiciary is also being imparted on by the system that we run. So we have looked at what is the role of the criminal justice reform system that we are looking at. We have looked at it, and we have seen that apparently the justice system that we are running is making strenuous effort to cope with the situation of things as it is. And there's a lot of gap which we have not been able to combat as it is. So the criminal justice system that is in place in Nigeria, there's no doubt, is very porous and very weak. And apparently, when you're talking about the criminal justice system, you are talking of chain of activities, starting from the law itself, the legislation, from legislation to the key stakeholders in justice, criminal justice system that we are looking at. You want to look at from legislation, the laws, want to look at law enforcement agencies, prominently the police, the DSS, and from there you want to move to the Ministry of Justice. You want to talk about the lawyers, the people, the state, And from there, you also want to move to private practitioner, like many of us here. Then you also want to move to the judiciary. And from the judiciary, of course, you want to move to the correctional facilities. Of course, correctional facilities recently has also been in the eyes of the storm. When we talk about the issue of Bobrisky and all of them now, they are in the public domain. I'm sure we can also relate with that. Then we also want to talk about what we have been able to do when you look at this chain of activities by all these major stakeholders that are involved in it. So principally in the penal code and in the criminal code, we'll be looking majorly at section 30, section 69 to about 108. We'll be looking at section 100 to 108 of the penal code and the criminal code. Both are actually talking about the same thing principally. We are talking about what constitutes unlawful assembly. The least speaker talk about section 40. Of course, for every right that is granted under the chapter 4 of the Constitution, there are always restraints and limitations. So the law has guaranteed that you are free to assemble, the gathering together to pontificate about your view, to talk about your dissatisfaction. Of course, the critical word there is peacefully. So when you look at some of the case laws that are in issue, even though many of such riots, many of such protestations, many of such assembly or unlawful assembly began as peaceful assembly. Of course, the case law have said to the fact that an unlawful assembly began as a peaceful assembly is not an excuse. So when you look at critically all those sections involved, you'll be talking about where 2 or 3. Criminal code is talking about where 3 and more. Penal code is talking about 5 or more, where they have gathered together to now conduct themselves in such a way that will make a reasonable person, a member of the public, to be apprehensive, to be afraid. Then it becomes an unlawful assembly. Of course, there's also a very thin line between what an unlawful assembly and when it becomes a riot. One, a felony. One, a misdemeanor. There's a thin line between them. When there's now actual violence from an unlawful assembly, it becomes a riot. And of course, punishment moves between 1 year to 3 years when it becomes a felony. This is the critical issue that a whole lot of people have been agitated about with this recent issue of arraignment of minor. A lot of people have expressed diverse views. Oh, they should have been taken to juvenile homes. They should have been taken to a foster home. They should not have been arraigned in the first instance. The lead paper talks about the weakness in our federal system. Why should they be brought from Kano to Abuja? Why should they be brought from their different states to Abuja in the first instance, in a federal system? Of course, this is not an avenue to begin to talk about the weakness in our federal system. Of course, we know it's heavily flawed. However, they have not been charged for terrorism. One of the major acts we'll be looking at also is the issue of the Terrorism Prevention Acts and the Terrorism Prevention Amendment Act, whereby, for instance, if they had been charged for terrorism, of course, under the Terrorism Act, which is the federal enactment, they will have been able to be tried in any part of the country, irrespective of where the crime is conducted. But here we are looking at issue of the minors being charged for treason. Another fallout of such charge is the role of the bail. The critical point about this issue of bail, people also have expressed diverse views there. The severity of the offense is always considered at every point in time by their lordship in determining the liberality of such of granting the bail terms. Of course, you may also query it. Why do you ask them to bring directors, civil servants? The lead speaker has been leading us in this Dasuki case. We have a court of appeal decision in that Dasuki case. We said no, you should no longer allow accused person or suspect or defendant to be bringing civil servants, directors, to stand surety in criminal matters. But unfortunately, today, as we speak, many of all those, they still have standard procedure. Of Because the lead speaker also talked about the major role of corruption. I'm sure as practitioners here, we are also very familiar with the fact that bail system is a very challenging system that we need to really be worried about. We have seen a system that has been developed whereby bail will be granted, directors or people in public service will be procured at a fee to come and, they call them professional surety. Even though there's a procedure in the Administration of Criminal Justice Act which has prescribed a body to be set up to participate in all of this. But you and I know there's a corrupt system that is in place where you procure professional surety in code, as we call it. And every time when some of all these difficult conditions are granted, we have to go through this corrupt system to provide all these sureties. And the system moved on. So, once again, I believe that here we also look at all the case studies. R&AO is 1839 case. We consider it where these thin lines also being drawn between what constitutes an unlawful assembly and what constitutes riot. It's the question of trying to juxtapose the issue of free assembly as granted by Section 40 of the Constitution and when it becomes a violation of the penal code and a violation of the criminal code as it is. These are the thin lines that are being considered in that case or in some of the cases that we refer to. Thank you very much. God bless you.
That was another good one. Please join me in giving another round of applause to Mr. Wale Balogun, Senior Advocate of Nigeria, who stood in ably well for the learned Senior Advocate Ahmed Raji San. I understand that the next paper presenter is going to join us virtually, so I will yield the mic to Mr. Paul DAUDU San to assist at this point in time.
Yes. I understand he's here. Mr. Adeyinka, can you hear us?
Mr. Adeyemi.
Adeyemi, sorry, sir. Mr. Adeyemi,
yes.
Can you hear me, sir?
Yes.
Sir. Yes.
I'm here.
Okay, sir. Please, sir, you have 15 minutes to share.
15?
Yes. Sir.
Okay. All right, let me just go straight to the topic. Good afternoon, everyone. I apologize for coming virtually. I wanted to come in person, but due to the this just concluded Ondo governorship election, I could not get a flight back to Abuja this morning. Yeah. So, the topic, criminal conduct arising from prevailing insecurity in the nature of terrorism, kidnapping, banditry, breach of peace, unlawful assembly, riots, violent protests, and other related offenses. The approach of the Commission, that's approach of INEC. In considering this topic, we look at election security as our reference point in considering this topic. And in our introduction, the Nigeria security challenges ranges from terrorism, insurgency, armed banditry, militancy, kidnapping, courtesan, breach of peace, and ethnic agitation to religious fundamentalism, elders-farmers clashes, and intercommunal clashes. Also cases of armed robbery, various forms of transnational crimes, gangsterism, and periodic electoral violence pervaded the country landscape with harmful effect on the cultural, economic, and social well-being of the people and the country. I just want to, because of the time factor, I'm trying to, I don't know whether you have my paper already there so that I don't waste the time.
Yes, it is here.
Oh, okay, thank you. Yes. As you all know, security is indispensable to the conduct of free and fair and credible elections. From the provision of basic security to voters at polling, at political party rallies and campaigns, to ensuring that result form, that's our results, are protected. The whole electoral process is circumscribed by security considerations. In view of the scale of general election, the number of people involved, the electoral materials that needed to be moved, difficulty of the terrain to be traversed, as well as the physical locations that need to be protected, such an operation is complex. It represents logistic and planning challenges that require a wide range of stakeholders, processes, location, and issues in time and space. The risk of violence is present in nearly every election. It can inhibit voter turnout, limit political campaigns movement, and push candidates to drop out, all of which call into question the credibility of an electoral process. This is particularly true of emerging democracies like ours, as they navigate new processes and challenges. The significance of electoral security for creating proper environment, electoral staff required to carry out their duties, for voters to freely and safely go to their polling stations, polling units to vote, for candidates and political parties to organize rallies and campaigns, and for other numerous stakeholders to discharge their responsibilities under the Constitution and the Electoral Act. In planning and coordination and deployment matters pertaining to electoral process, where coordinated security is a fundamental requirement for success. Similarly, adequate security is an important precondition for the deployment of electoral assets and sensitive materials to wards and polling stations. Adequate security increases the level of participation of political parties, candidates, and voters in an election. It also enables a more objective coverage of events by the media, easier circulation of voters' education, messages, and materials. And what is the approach of INEC to these security challenges? The Commission is committed in its way to securing the electoral process in an environment that in recent years has been hit with widespread of violence and terrorism. In fulfilling its mission in Nigeria, the Commission has conducted several elections at the national and state level, despite threats of terrorism, kidnapping, banditry, breach of peace, and unlawful assembly, and other related offenses, by adopting the following methods. 1. For the first time in the history of electoral security in Nigeria, the Commission established the establishment of Interagency Consultative Committee on Election Security, ICES. And this is a common platform responsible for the coordination of security matters and pooling of scarce resources, particularly personnel, in dealing with common security challenges. Through ICES, security services are promptly intervened and forestall potential crisis situations that could have gotten out of hand across the country. And who are the members of the ICES? At the national level, we have it at the national level and the state and local government level. At the national level, we have the chairman as the co-chair and other national commissioners. Then we also have the National Security Advisor as also a co-chair. The Secretary to the Commission, the Inspector General of Police, the Chairman of Police Service Commission, the Director General of DSS, the Chief of Army Staff, the Chief of Naval Staff, the Chief of Air Staff, the Commandant General, Civil Defense Corps, then the Chief of Defense Intelligence Agency, DIA, the Controller General Nigerian Correctional Service, Corps Marshal FRSC. And I listed them down. I don't want to be running through all of them. We have all the security, including the chairman of EFCC, ICPC, DG of NOA, the Controller General, Nigerian Immigration Service. They are all members of this ICES. Then what is the role of this ICES? 1, coordinate the design of an election security management for the Commission. They also develop locally focused plan for providing security before, during, and after the election. harmonizes the training, deployment, and action of security personnel on election duties. They also advise our state offices on rapid response to security threats around elections, including voters' registration. Ensures a reduction in transaction costs to INEC in dealing with individual security agencies on issues of election, assessing existing security threats across the state that have implication for elections, and produce a red, amber, and green electoral security map, which they regularly updated. They also evaluate the performance of security agencies on election duties and recommend improvement and sanctions where necessary. They also coordinate the deployment of security personnel on election duty. Now, the second approach we also do due to these security challenges, and we know that there are people are displaced during like this Boko Haram in the northeast. There were displacement of voters. Then the commission decided to create voting centers at IDP camps. So internally displaced persons are qualified Nigerian voters relocated either temporarily or permanently from their usual place of abode as a result of conflict, insecurity, or other natural or man-made emergencies, so as to enable are unable to vote in their normal delimitation or polling station. IDPs are classified into two categories on the basis of location, namely intrastate and interstate. Intrastate is IDP camps within the state. Intrastate is IDP camps that are relocated to another state from where they initially registered as a voter. Then the third one is the establishment of National Interagency Committee on Voter Education and Publicity. INEC recognizes the fact that community engagement initiative is also crucial in achieving peaceful election. INEC works closely with community leaders and civil society organizations to promote peace and encourage voter participation. Voters' education campaigns are intensified, especially in regions affected by violence and insurgency, to ensure that citizens, especially those that were displaced, were informed about their voting rights and the measures in place to protect them through the setting up of Interagency Committee on Voters' Education and Publicity. We also have it at the national, state, and at the local government level too. And I stated the objectives of the committee. The committee is to ensure interagency cooperation in voters' education. They are also to promote public and private partnership on voter education. They are also to ensure proper coordination and monitoring of voters' education messages and materials. Another approach the commission adopted was to introduction of technology. Technology played a pivotal role in enhancing electoral process and efficiency. The introduction of bimodal voter accreditation system (BVAC) for voter accreditation and the INEC result viewing portal (IREV) for real-time election result dissemination. Election result disseminations were critical in boosting voter education in the electoral process. These technological interventions addressed concern over electoral malpractice and facilitated a more transparent tallying and reporting system. The Commission also introduced an application called INEC Security Alert and Notification System, INEC SANS. This is an application developed by the Commission, which allows for an on-the-go communication to mitigate and forestall critical incidences or provide immediate response if they occur. Utilization of INEC SANS greatly enhances preventive and responsive action towards security challenges during electoral activities. I also stated the objectives of INEC SANS, the application. is to provide timely security threat notification and alert to appropriate responder. To provide real-time information needed by the responder to mitigate or eliminate adverse incidents. It is also to provide detailed incident report and analysis and to mobilize a coordinated response to security threats between the field asset and the response team. Then we classify the threats on the app. We have critical level, high level, medium level, and low level. And that the response time is also stated. Now, at this junction, it is important to state that the Commission's experience since 2011 general election has shown that some of the most serious challenges to election security have been associated to deployment of security personnel. While there were tremendous strides in deployment in 2023 compared to previous elections, there is still room for further improvement. Issues such as early and adequate deployment to polling units, the provision of escort protection for election officials, and sensitive election materials, preventing violence between supporters of one political party and another, the presence and influence of thugs and militia groups in certain parts of the country, as well as attacks on electoral personnel, are outstanding issues which need to be urgently addressed so as to enhance the credibility and transparency of the electoral process. However, election security is an issue that cannot be left to security agencies and electoral management bodies alone. All other stakeholders, such as the media, the National Orientation Agency, community leaders, CSO, etc., have a greater role to play in the task of securing the electoral environment. Now, in the build-up to the 2023 general election in Nigeria, the Independent National Electoral Commission faced daunting challenges amid widespread insecurity and socio-economic turmoil. There was apprehension in the country on the wave of insecurity across Nigeria, from Boko Haram terrorism in the northeast to banditry and adoption in the northwest, to farmers' herders crisis in the north central, to the self-determination agitations and bombing in the southeast,
Sir, you
to
have 5
militancy.
minutes. You have 5 minutes, sir.
Oh, yeah, I also round up. Yeah, to massive oil theft in south, while the southwest is plagued with kidnapping and untoward acts of ritualists. Nigeria seems to be under siege, and there is no safe haven anywhere. The task of conducting free and fair, credible elections seems Herculean. The former president of Nigeria Christian Association, Reverend Samson Ayokunle Olasupo, warned that the 2023 general election might not hold as planned due to the rising insecurity across the country. Legal luminary Chief Afebalola SN also wanted Nigeria to suspend plan for the 2023 general election and opt for a stopgap interim government. Despite all this growing concern over insecurity in the country, then INEC was determined to go ahead and actually conducted the 2023 general election successfully. INEC's strategic measures and innovations stated above ensure the successful execution of the electoral process, showcasing resilience and adaptability in the face of adversity. The Commission implemented robust security arrangements to protect electoral materials and personnel. Collaboration with security agencies was strengthened to secure polling units and INEC facilities, which had been target of violent attacks. Advanced logistic planning ensured the safe transportation and delivery of electoral material, even to remote and conflict-prone areas. Now, I also stated the number of cases the Commission received, the number of arrests that were made after the 2023 general election. The police arrested and investigated 774 suspects for various shades of electoral offences and forwarded 215 case files to the Commission at the conclusion of the investigation. The Commission has since commenced prosecution of electoral offender by partnering with the Economic and Financial Crime Commission and the Nigerian Bar Association in order to ensure swift prosecution of the electoral offenders arrested in the course of the conduct of 2023 general election and the off-season election. Successful prosecution have so far been recorded in Gombe, Kebbi, KOGI, Kwara, and Lagos State, while the remaining cases are at the different stages of trial in all the states of the Federation. Having regard to the challenges being encountered in the investigation and prosecution of electoral offenders currently, there is urgent need for the legislative action before the 2027 general election by implementing recommendations of Justice Ways Committee report of 2008 and Justice Lane Committee report on the 2011 post-election crisis. The two reports both recommended, among others, the establishment of the Electoral Offences Commission and Tribunal, vested with the power of arrest, investigation, and prosecution of electoral offenders. A nation that does not punish violators of its own law is doomed to be repeating its own misfortune instead of making steady progress. Passing the Electoral Offences Commission and Tribunal Bill, enabling swift prosecution of electoral offenders and their sponsors, is essential for enhancing election integrity. In conclusion, the resilience and determination of INEC in collaboration with nation security forces, civil society, and international community underscore the collective commitment to democracy in Nigeria. The successful conduct of the 2023 general election and other off-season elections amid terrorism, kidnapping, banditry, breach of peace, unlawful assembly, and other related offenses not only demonstrated INEC capacity to navigate through crisis, but also reinforce the democratic resolve of the Nigerian people. This achievement marks a significant milestone in the country's democratic journey, setting a precedent for the future elections in similarly complex and volatile environment. Thank you very much for your attention.
Thank you very much, sir, for that very robust contribution. Shall I stay back because we may have some questions from the audience from you. We are now at the interactive stage. Please, let's give him another round of applause. Before we move to the question and answer, permit me to recognize Dr. John Agada-Elechi, SAN, who is here with us. Thank you for joining us. We also have with us the General Counsel of the FCT, who is no other person than Mr. Salman Dako. You are very much welcome, sir. The chairman has asked me to assist with the question and answers, and we have until 3 o'clock. So what we will do is that we will take interventions here physically. We also have asked Mr. DAUDU to note any interventions in LOKOJA, and then the technical should also let us know if we have anyone online. So let me start with the privilege of those who are in the room. So if there's anybody that has any contribution should be restricted to 2 minutes, and your question should be a question. Only one question per person. One question. Only one question per person if you have a question. There any comments in 2 minutes? So do we have any contributions, please? Any contributions? If by show of hand, any contribution? Okay. Abdullah Yahya, Senior Advocate of Nigeria, has a contribution. You have the floor, sir.
The chairman, sir, all protocols duly observed. My intervention has to do with this issue of which the lead speaker has articulated well. You find that in most states, just as did happen with the end bad governance incidents, in most states, the practice is that the police will move defendants from wherever the offense is committed to the state capital for the purpose of being prosecuted in the state capital. Now, given that situation, you also have a situation in which the courts will then ask the defendant to produce a surety of a particular cadre in the civil service for a person who is unfamiliar, is coming into an unfamiliar territory. How does he get somebody who knows him and who is willing to take him on bail in an environment where he knows nobody? I give a typical example of Kaduna. If you take somebody from Gwantu to Kaduna and you ask him to get a person who is of the rank of a director in Kaduna, who is a resident in Kaduna and has property, it becomes extremely difficult for him. So you're virtually saying you can't get bail because you're not asking him to produce his district head or somebody in his own community. How do we get around that problem?
Thank you very much, Leonard Silk. Do we have any other contributions within our Rule of Law Development Secretariat? Yes, Emmanuel Oni. But let us take Chairman Banawa first before we take Emmanuel Oni. Please, technical, inform me if there's anybody in Lokoja, please.
Thank you. My contribution is basically talking about the minors that were brought to Abuja for prosecution. I would like to say that there's still more that need to be, done when it comes to issue of structures, because we don't have structures that is talking about rehabilitation, homes where these minors will be kept, because up until this time, these children or minors that have come in conflict with the law are still being assembled together with, maybe adult offenders. So that's my contribution, that there's need for structures. It's okay if a minor has committed an offense, and it's okay for the minor to know that for this, you can't be punished. But of course, in an environment whereby the child will be improved, rehabilitating, or as against punishment. Thank you.
Hello? Abdul, do we have anybody in, do we have any contributors there? Abdul, can you hear me? We can't quite hear you.
Okay.
Okay.
Can you hear me now? Yeah. We have a contributor here. We have one.
Okay, please, you can go ahead.
Okay, thank you.
Good afternoon. Can you hear me, please?
Can go ahead.
Please, can you hear me?
Yes, we can go ahead, please.
Oh, okay. First, I want to stand on the executive protocol, and I want to thank the convener of this conference for his immense wisdom on bringing topical issue on the country to the front burner. On the issue of corruption, I would like to respond to...
Can you introduce yourself, please, so that we can note you?
Okay, my name is Dr. Christopher Balogun. I would like to respond to the issues that are raised by the EFCC chairman. I want to appreciate him for his doggedness in addressing issue of corruption. But first, I will highlight on the problem when it comes to corruption in Nigeria. Some of the acts and the laws that we have also facilitate corruption. I'll mention just a few, like the 1999 Executive Immunity Clause, 2015 Plea Bargain, 1991 Land Use Act, 2007 Procurement Act, 2021 Electoral Act. If I quickly look at the Electoral Act, before the enactment, everybody was excited that with the Electoral Act, the issue of election will be over. Electoral malpractice are efficient. But the convener, during one of his conference, highlighted that it will solve the electoral problem because of the fundamental issues that weren't addressed. To sum it up, in the Electoral Act, everybody talks about the low-key players. Nobody talks about the sponsors of this violence. There's no penalty for them. I looked at all the acts. There's no penalty. We know that not the talk that sponsor electoral malefficient vote buying. It is I don't. It's the executives, and you can't address them because of the Immunity Act that is here that's been enacted in 1999. As far as this in the Immunity Act persists, corruption will be very, very difficult to address. We know about the plea bargaining. It started in as far about 1692 during the Salem witch trial, whereby the safe witch confessed there will be leniency on their crime. We adopted it before without even looking at the involvement. It evolved over time. This plea bargain also is one of the factors that facilitate corruption. We are not here to preach about corruption or the crimes, but I want to highlight that whether we like it or not, the convener, I love the fact that he has been telling Nigerians that if this corruption persists, Nigeria will go down. We are early with kid love. Over years, we can see the destructive aspect now compared to 20 years ago. Highly demonized military regime seems like a paradigm now. I remember during the military era.
Please, you have 1 minute to round up, please.
Okay. As I round up, what I'm saying is that we have never, there's never a severe penalty for corruption. The destructive effect now is a reality that we must enact severe law for it. Like in Rwanda, when they came out from the genocide, the president Kagame knows that if he doesn't address the issue of corruption, Rwanda will never get out of his economic travail. So what he did is that for any offense that undermines national prosperity and growth, it carries either life imprisonment or death penalty. It's high time that we do it. Like in routine activity theory, the summation of that theory is that we have a motivated offender, suitable target, and lack of capable guidance. Nigeria is a perfect example of it. People are motivated in form of offense, especially when it comes to the issue of security. We are the suitable target. We can't carry arms, we can't do anything, and there's nobody to protect us. So Nigeria to make sure that this corruption must be made, as the convener said, if you don't address the issue of corruption, honestly, we just be pretending they call for a parliamentary system of government. It will collapse. It's high time that we punish these offenders, and so that we can save Nigeria. Empire's hegemony has collapsed.
Thank you very much. Sir. Thank you very much.
Okay, thank you very much.
Thank you very much, sir. Please, let's give him a round of applause. We have some contribution. Abdul, do we have more contributions there in LOKOJA? I want to proceed.
Yes, we have from magistrate missed.
Okay, please let us say, please,
Okay,
sir, your worship, please introduce yourself so that we know you.
Adejo Ben, Chief Magistrate, KOGI State Judiciary.
You're welcome, your worship.
My contribution is about this unlawful assembly. We have in our constitution section 4 giving the right of assembly to citizens. The law also provides for an unlawful assembly. And this is where the problem lies. In the bad governance protests, which we had recently in August, the assembly that was made turned out to be unlawful because we felt that some persons became violent, things were destroyed, among others. But I feel that what should have happened is that the government has the machineries to provide provisions for people to exercise their rights of peaceful assembly. Government also has the machineries to provide against infiltrations by hoodlums. Where the unlawful assembly came from was that, to my mind, the assembly that was made to ventilate views by citizens were truncated by people who felt that what that assembly shouldn't be And so we saw it in the news and everywhere that they now had to respond to those who came against them. And so the assembly became very, very violent. And some of them were arrested and put under incarceration. It is my suggestion that government should make adequate provisions wherever citizens are aggrieved and they are interested in ventilating their grievances, so that those who may come out under the guise of protecting their self-interest against the people will be met with adequate sanctions. By this, our rights as citizens to come out for protest, peaceful assembly, on whatever front it is called, will be achieved. Thank you, sir.
Thank you very much, Your Worship, for that very, very thought-provoking contribution. I think that is all for LOKOJA for now. If there are any more, Abdul, you advise me. Can we have more contributions, sir? I understood Emmanuel Oni wanted a contribution. Sir, you also wanted to say something, sir. Please. Okay, sir, you can ask your question. Please indicate who the question is directed to. Thank you.
All protocols are duly observed. I am Lieutenant Commander B.A. Achimugu from the Nigerian Navy. I have a question for the lead presenter. I enjoyed the presentation. I just want to ask a question. First of all, let me just make this caveat very clear. I'm not speaking for any law enforcement agency. I'm speaking in my personal capacity. Now, from your presentation earlier on, you made an argument on the issue that, on the need that some of the offenses could be appropriately dealt with in areas where they occur. Like you cited the example of Kano. Now, my question is, how do we juxtapose this with the reluctance of some state governments to handle some of these cases when they happen in their area? I'm citing this specifically in respect of the recent drama between one of the law enforcement agencies and a former state government, whereby we want to prosecute, they say leave our man alone and all of those things. How do you balance it so that in referring these cases back to where they happen, and you have a situation where the state government in the affected area is not willing or is unwilling to support the prosecution of those cases? Thank you, sir.
Thank you very much, sir, for your contribution. Emmanuel Oni has a contribution is coming. Thank you very much.
My name is Emmanuel Oni, Senior Associate DAUDU and Co. My question relates to the issue of the reference the chairman of the EFCC made to improving their mode of investigation, their internal protocols. First of all, I'd hoped he would say whether that document is public, because the purpose of improving your internal procedure is for people to be able to know when their rights are being breached and for people to be able to hold you to account. So when, as I know for sure that that document is not a public document, we cannot really see how far it goes. Secondly, I would like to ask now, when an investigation is done, we've observed severally that the EFCC and many other organizations are reluctant to release an investigation report. This investigation report is very crucial in many cases to see whether your investigation is fair, timely, and transparent. Can we not enact a law that mandates investigative bodies to release their investigation report within a specific timeline to help improve the investigation process and the criminal investigation system generally? Thank you very much.
Thank you. I think the lead presenter will take that question. There's also a question that was asked by the Chairman Banawa branch about bus-style centers, and also being somebody who is a member of the Administration of Criminal Justice Committee of the FCT. It's an issue we have been battling with. In fact,
recording in progress.
Assessment of all the bus centers and juvenile homes in the FCT. I think it's something that needs to be done because most of them are falling into disrepair. So I don't know what the way forward is. Given the question she asked, that the law doesn't allow us to lump up juvenile offenders with senior ones. So I don't know if there's any other question or comment. Okay, we have one more from, hello? Yes, okay. Mrs. Dangana, we can take your question or comment. You're welcome.
Good afternoon. The convener of this Rule of Law conference, may I lean on the existing protocol? My question goes to the lead presenter, Elana Silk, P.O.W. and Co. He has mentioned a number of cases that have been decided in respect of terrorism and kidnapping. And with the space of these offenses in recent time, for me, I feel that these cases should be more. Now, what will be the situation wherein you notice that these offenders are before the court, and then the prosecutors are not prosecuting them, and then the court also decided not to let them go because of the severity of their offenses? How should that be balanced? If the prosecutor is not prosecuting these offenders, should the court leave them behind bars simply because they have committed heinous offenses? Shouldn't they also be let go since the prosecutors are not ready to do what they should do? Because I have a case that is like that, and what should be the justice to the defendants in that circumstance wherein he is before the court and yet he is not being prosecuted upon being charged for those crimes of terrorism and kidnapping? Thank you very much.
Thank you very much, madam. I think for now we can draw a curtain on contribution. Please, let's give up all the contributors a round of applause. We now, at this point, I will hand over back to the chairman, who will definitely give his closing remarks. But I understand there are one or two questions that were raised. So I think the lead presenter can answer most of the questions. The lead presenter should be given the microphone to answer the questions and give his final thoughts.
With respect to the last question, with respect to this issue of just tagging a charge, terrorism, murder, treason, I believe their decision to the fact that the judges are allowed to, even at the bail level, to actually look at the proof of evidence, to be able to use their discretion to grant bail, whether severely or in liberal terms. Otherwise, there have been so many decisions, they just say murder. So the moment they say murder, okay, no, it's not bailable. So in such matters now, where because it's been tagged terrorism, then my lawyer said, no, I can't release these people. Whereas maybe if a second look is taken at the proof of evidence, some of them may actually not be anything related to murder. Just like this minor case. I'm sure if the judge, he has exercised their discretion, but if he had looked at the proof of evidence, perhaps he will have seen that it's just been tagged treason. The fact that is there may not support treason. Thank you.
I understand the first question you say that how do we get around the problem of this transportation of accused persons from one location to the other? I think it is part of what they call prosecutorial discretion. And where a person is alleged or accused of committing an offense, criminal offenses are usually territorial in nature. The courts exercise jurisdiction only by virtue of the fact that an offense took place within that particular locality, and it is only courts within that jurisdiction that can try such an offender. That at a point in time, the EFCC and some other prosecutorial agencies banking on the single jurisdiction of the Federal High Court resorted to taking cases, and that was not during the tenure of the present chairman, but sometime in 2007. To make life difficult for you, they move your case to Maiduguri when you committed the offense, or alleged to have committed the offense in Lagos. And that was why the Court of Appeal, I don't know if Justice Aredola was in the panel, decided Ibori against the state and said it amounted to forum shopping to move someone from the location where the offense took place to another place. So it is really calls for the vigilance of counsel. Calls for vigilance of counsel to be able to file the right applications in court so as to seek for a quick discharge of persons who have been detained. And that will also answer Mrs. Dangana's question, which is to the effect that really if you have someone who is being played like the table tennis between the prosecutor and the courts, the prosecutor is not willing to proceed and the courts are not willing to grant bail because of the severity of the charge, it taxes your ingenuity as counsel to come up with the right applications, which will be heard, and if refused, you go on appeal. We couldn't get the Federal High Court to budge on its insistence on sitting in Kaduna over offenses that took place in Asaba in Delta State. However, when we appealed to the Court of Appeal, the Court of Appeal applying one quo against the state and other decisions, said that it was forum shopping. So at times, you don't leave matters between yourself and the trial judge. The trial judge is, with respect, probably a local player, knows the DPO, knows the Commissioner of Police. The favors are usually asked, we are human, and therefore this refrain that when you release these people on bail, they go back and commit the same offenses. The judge may have been maybe victim of some of these local criminal acts, and therefore at times you save them a lot of trouble by taking it to a higher level, applying for fundamental rights, and doing things that will at least save them, you know, the pressure that local handling of cases brings. So it's up to counsel really to move the matter to another level so that those ones relatively detached can give that order that needs to be given. The other question asked is relating to also to the issue of the federalism. I think the Lieutenant Commander Chimugu asked the question, but I will just put it as I understand it, which is that where it appears that there is lack of political will in a location to prosecute the matter, like happened in Kano, let's use Kano as an example. What I expect would have happened was that police have been adjudged as having the power to prosecute offenses within state jurisdictions. Indeed, it is there, that is where they hold sway. So it was an aberration for them to have on their own taken the case from their jurisdiction to Abuja, perhaps to satisfy their masters in Abuja or for some other political consideration. Now, naturally, and let us hypothetically consider, say, even the same Kano. For political reasons, and you know Kano is almost split down the middle in terms of political allegiance to either the party in power or the party in opposition. Now, if the governor, for one reason or the other, has developed cold feet from asking the Attorney General to prosecute because of the local backlash. Because prosecute 100 people, that's about 10,000 voters that you have lost in the next election. So therefore, he may be reluctant. He has a ready-made excuse, which is that it was the Commissioner of Police that should have gone to court, filed the charges in the magistrate court. Then the state can then broker some kind of peaceful political arrangement. But the process of charging them to court, they would have spent 2 weeks, 3 weeks in detention. The message would have been sent. These are probably things that require slap on the wrist to solve. So the mistake happened. I don't want to drag the state government into it. For political reasons, if I was the governor, I would not be willing to prosecute 100 of my citizens all in one fuel swoop. I probably would take 10 or 15 of them and then use it so that elders can come and beg. After 3 weeks, I'll tell the Attorney General to enter a nolle prosecute and then make political capital out of it. That is why these processes are there. But for the police to lift them up from their locality and take them to Abuja with the government not saying anything, as if, well, you solved our problems for us, only to wake up and run to Abuja when the whole thing had exploded and started spending serious money. Because to rehabilitate 100 people, or more than that, or 300, buy new clothes for them and still give them money, give their handlers money, you would have saved all that if you did the right thing in the first place. So it's really about fundamental mistakes having been made, and most importantly, the due process. You see, when we inherited this system from the colonial powers, there was a particular structure that was to be followed. You can't start when there was a British divisional officer, maybe in charge of Kakuri, expect him when the matter comes up to transfer the case from the station to Kao. It's not possible. He will deal with it within his own jurisdiction. But eye service and psychophancy and so many things, looking for promotion, we want to make a DPO run with his case file to Abuja to come and seek for advice so that they can say he's a good boy. So it's the Nigerian factor. It's skating between the issues of corruption. So we just have to do the right things the way it should be done. Then we'll get a solution. Then the issue of Boston. It's still about not doing things the way they should be done. When last did you go to the Boston institution in Kaduna, Mrs. Ajao? Have you been there in recent times? So it's no longer even a remand home. They used to call it, when I was a child in Kaduna, yes, they used to call it a remand home for what they say in Hausa, Kangangarum Yara. So it was there. But our present crop of leaders do not maintain such structures. And there is a purpose for it. And there are several states now that their governors have never heard of what is called a juvenile detention center. They don't know the objective, and because in most cases, well, the attorney generals are enjoying being in the executive council. Every lawyer knows that the system is not complete if you don't have anything within the criminal justice system to take care of children between 9 and 14, or even 16. It was working. Okay, kudos to Kanu. Yes, because Kanu is one of the most populous states in Nigeria, and one of the richest states too. And therefore, so one of the reasons, one of the things that you should take back home is, which will be captured in our communique, is that at least for every local government, while there is a primary health center, there should be something to take care of people who need to be reformed. A juvenile center is reformatory. It's not punitive or retributive. So I think these are things that we need to take back to our respective jurisdictions and pass on to the powers that be. That's why they may have a change of priority. I think I have tried to cover all the questions. So if anybody feels I've not answered, please pardon me. You can meet me privately to explain to the best of my ability whatever it is I've omitted now. Thank you.
Excuse me. Yes, distinguished participants, like I said earlier on, that we are in for a very, very good treat, a learning curve that will be with us for a very, very long time. So when we get the hard copy of the papers presented, please let us treasure it. So a very big thank you and appreciation to the lead paper presenter, Chief J.B. DAUDU, founder and coordinator of the Rule of Law Development Foundation. Similarly to Mr. Wale Balogun-san, who ably stood in for Mr. Alhaji Ahmed Raji San too. And then we thank Mr. Adeyemi Olufemi, the director INEC, who is representative of INEC, who joined us virtually. Well, they say the statement that a tree cannot make a forest, to me, is an understatement. What do we have here? Rule of Law Development Foundation is doing the positively unthinkable by drawing our attention to the dangers ahead and how to attain tremendous results, both visible and invisible. The Rule of Law Development Foundation imbibed the doctrine of covering the field in legislative practice. That is why it touches on offenses, correctional institutions, and all others. For instance, we know our failings, and the question is, how do we contain the precipitous fall into the bottomless pit? We kept talking about corruption. What are we doing about corruption? We cannot say an end to it, but we can at least bring it down to the barest minimum. The fact remains that we have problems and we know the solutions. So why are we still in the dungeon? Please let us find answers. Why are we where we are today? What next? We need to look both inward and outward. Again, the fact I will still repeat remains that without due enforcement, rigid enforcement of rule of law, progress and peace in the polity will remain delusionary and a pipe dream. One and all, we owe it a duty to play our part and do our bit. The Rule of Law Development Foundation, ably guided and led by Chief J.B. DAUDU-san, stood and is still standing solid like the Rock of Gibraltar, and we continue to blaze the trail towards enthroning practical solution to seemingly intractable and endemic problems. And that is where they need our support. Let us come here, imbibe, and pick droplets of wisdom being churned out by the resource persons who are invited to come and address us, and then let us turn over all such learnings into practical experiences that will serve the purpose it is meant for. May I, at this particular junction, in rounding up, maybe use myself as a practical example. I think in 1962, I was about 13 years old, stubborn. So one day, my father took me, said I should say bye-bye to my mom. I said, I didn't know where he was taking me. Wallahi, he took me to Magajingeri remand home. And he pointed it and said, you see that place? That is why they always, take children like you who don't want to listen to their parents at home. I cried my eyes out. He made me promise that I will turn a new leaf. I promised I will turn a new leaf because I know the remand home. It's on our way to school. We always know those who are kept there. No trial, no nothing. It's your parents who will just take you there. They dump you there. When you learn your lesson, they bring you out. If you don't learn, you stay there for as long as possible. So all these things, they yield practical results and dividends. And that is why we should, like the late president, like DAUDU said, Deputy DAUDU said, that anywhere you have health center, have this type of remand center. But above all, parents should do their duties and take care of their children. Not what we have nowadays, that people will have children that they do not intend to take care of. It is not Islam. Thank you so much. Let us give another resounding applause to the lead paper presenters and all the discussants. And thank you for your attentiveness and your listening. God bless you all.
Let us give our chairman a resounding round of applause. Let us give all our panelists a resounding round of applause too. We have had an intellectually stimulating session, very practical, interactive, on a very, very, very burning and front burner issue affecting administration of criminal justice. And we want to thank the Rule of Law Development Foundation and the coordinator for giving us this platform for fertile exchange of ideas. I'm hoping that with the various stakeholders we have here, we'll be able to practicalize some of the fallout of this discussion into our various areas. I, for one, definitely being a branch chairman, I will go back and also see what we can do to implement some of the ideals we have within the jurisdiction of the FCT. And I challenge all of us here to also do same, not to just listen to papers and come every time, but it's for us to practicalize what we have here. So once more, let's give the resource persons a resounding round of applause. Thank you, Mr. Chairman, for... Yes, I understand that the Secretariat are putting everything on flash for those who have been registered. I don't know if I'm still correct on that, for the resource persons. So there will be a complete flash drive where all those documents will be. I will also have a Rule of Law WhatsApp platform where all the documents will be dropped. So if you are here, please endeavor to leave that's why we have taken your details, so that we can send them electronically to you, so that you can have some of the papers that have been presented. So thank you very much. And to our distinguished audience in LOKOJA too, thank you very much. Give yourselves a resounding round of applause too. You've done fabulously well. I can see my Lord still there. I can see the various directors and your worships also there. Please join us tomorrow, because it is a week-long discussion. And tomorrow we are now looking at a very, very important topic, which is lawyer-client privilege communication, and the decision in Aclrc versus Central Bank of Nigeria, and the effect this decision has on our money laundering laws and the provisions of our rules of professional conduct. And we, luckily enough, I think we have Aclrc here. He has been here since, and he's a panelist on that session together with Isi Ukala, Yusuf Ali, and then several others. We're having the representative of CBN, MBA, and also Sylvanus Tahir SAN of the AFCC. So please, we are starting 9 o'clock on the dot with that session. And then we also have a showcase session on FCT as a model for crime fighting in Nigeria. And we have the representative of the Honorable Minister of the FCT there, and Professor Benedicta DAUDU, and the Commissioner of Police of the FCT. We also have the General Counsel, who is also going to be here with us at that session. Let's give him a round of applause. He's even here today.
So we have a robust discussion tomorrow, and we are starting at 9 o'clock on the dot. So at this point in time, we will close with the national anthem, and then we will have lunch. I understand it's the same mode of service for lunch, but before lunch, we're enjoying some of our resource persons to take photographs again and network before we have the lunch. So can we have the national anthem? And I thank everybody for staying till this period.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. To hang on to our children a banner without stain. O God of all creation, grant this our one request. Help us to build a nation where no man is oppressed. And so with peace and plenty, Nigeria may be blessed.
Nigeria indeed be blessed.
Please, we have a lunch, so you can remain in your seats while we ensure that the lunch is served properly.
Maybe the chief in your environment. Has also be thought of goal setting. Now, I set a goal last week to change IC, but now I can change it very well.
And we talked about self-esteem. We have two different types of self-esteem. We have low self-esteem and high self-esteem. High self-esteem is when you are proud of yourself, but low self-esteem is when you hate yourself. You don't like the way you look or the way you act. And you should not let people to get to you